I want you to just close your eyes for a second. Imagine you're at a hardware store. It's a Saturday, you've got a project.
Yeah.
You buy this huge piece of timber, a 12-foot beam that weighs 100 pounds.
Heavy.
Right. You're wrestling with it, and this friendly employee in an orange vest, he drives up on a forklift and says, hey, let me get that for you.
Okay, great.
He drops it into your truck, throws a red flag on the end, gives you a wave. You think, great service. You drive off. But 10 minutes later, you turn a corner, and that 100-pound beam slides right out of your truck.
Oh, no.
You scramble out to get it, and while you're standing in the middle of the road, a car slams into the beam, swinging it around like a baseball bat. It smashes into your leg and just shatters your kneecap.
It is a visceral, just a nightmare scenario. And it is the exact set of facts that launched a major legal battle in Washington state.
It really is a nightmare. And, naturally, the injured man, Henry Gano, he sued the lumberyard. He basically said, you guys loaded this thing. You helped me. How is this not your fault?
Right. It seems like an open and shut case from his perspective.
It does. But today, on this deep dive, we are going to find out why the court looked at that shattered kneecap and said, sorry, Henry, that's on you.
It sounds harsh, but it forces us to look at a very specific corner of the law. We are analyzing the case of Gano v. Lanogo Corps, but the bigger topic here is something called the voluntary rescue doctrine.
The voluntary rescue doctrine. Sounds like something out of a superhero movie, but I have a feeling it's a lot more technical. What's our mission for this deep dive? What are we trying to uncover here?
Our mission is to map the analytical path of liability when someone tries to be a good Samaritan. We are going to dissect the duties, or, the total lack of duties, that exist when a business or a bystander decides to lend a hand.
Okay.
Specifically, we need to understand the 3 precise conditions under which a rescuer becomes liable for negligence. The court in Gano applies the restatement of torts with incredible strictness, and we are going to see exactly how that plays out.
Okay, before we get to the lumberyard and the forklift, I want to back up to the very beginning. To understand the exception, we need the rule. In the eyes of the law, if I see someone struggling, say they're drowning or their car's on fire, do I actually have a legal duty to help them?
This is where we have to start, and it is often shocking to people. The foundational principle in American tort law is that generally there is no duty to rescue.
None at all.
None. You can sit on a park bench, watch a blind man walk toward a cliff, and legally you can just sit there and finish your sandwich. You have no obligation to warn him or stop him.
That always feels so cold. It feels like the law is encouraging us to be selfish. Why is that the baseline?
It's rooted in a philosophy of individualism. The law is very hesitant to force affirmative action on citizens. I mean, it's one thing to say, don't hit your neighbor. It's a much bigger step to say, you must save your neighbor. So the baseline is, mind your own business and you won't get sued.
Okay, so that's the general rule, no duty. But obviously people do help. The lumberyard employee did help. So how does the voluntary rescue doctrine change that baseline?
It creates a specific and very narrow exception. A duty of care arises only when a rescuer knows a danger is present and affirmatively takes steps to aid the individual.
So the moment you step in.
The moment you cross that line, once you say, I'll help, you have voluntarily assumed a duty. But, and this is critical, you haven't assumed a duty to save the world. You've only assumed a duty not to make things worse.
That seems like a really fine line. I think most people assume that if you start helping, you're responsible for the outcome. If I try to perform CPR and I fail, am I liable? If I help load a truck and it falls out, am I on the hook?
Not necessarily. It is not about whether you succeed or fail in the rescue. It is about the trajectory of the danger. We look to the Restatement of Torts, sections 323 and 324A. The rule is strictly this. A person is liable for attempting a voluntary rescue only if their actions make the plaintiff's situation worse than it would have been if they had done nothing at all.
Worse. That is the magic word. But what does that actually mean in a courtroom? I feel like worse is, subjective.
And the law hates subjectivity, so it defines worse very clearly. There are 3 and only 3 exclusive ways a rescuer can make a situation worse to trigger liability. If you don't hit one of these 3, you walk away free.
Okay, lay them out for me.
First, by increasing the danger. Second, by misleading the plaintiff into believing the danger has been removed. Or third, by depriving the plaintiff of possible help from others.
Those sound abstract. I want to make sure I really get this before we attack the Gano case.
Yeah!
Let's do some visceral hypotheticals. Let's stick to the loading dock theme. Give me an example of the first one. Increasing the danger. How do I help someone load a truck but actually increase the danger?
Okay, imagine a customer has a stack of plywood in their truck. It's sitting flat, it's heavy, but it's stable, it's not going anywhere. An employee runs over and says, "Let me help you organize that." He lifts the stack and shoves a round log underneath it to prop it up, making the whole stack wobbly and unstable.
Okay, I see that. Before the employee touched it, the wood was safe. After he touched it, it was a death trap. He didn't just fail to secure it, he actively created a new risk.
Exactly. He altered the status quo for the worse. That is increasing the danger.
All right, what about the second element? Misleading the plaintiff. This feels like it involves communication.
It does. It's
Okay.
all about reliance. Imagine the employee loads a refrigerator into your truck. He ties a knot that looks fancy but is actually a slip knot that will come undone instantly. He looks you in the eye and says, "I used a trucker's hitch. That fridge is welded to the truck. You don't need to check it."
And because he said that, I don't check it.
Right. If he hadn't said anything, you might have checked the knot yourself. But his specific assurance induced you to drop your guard. You relied on him, and that reliance got you hurt.
Yeah.
That is misleading.
Got it. It's the false sense of security. Now, the third one, depriving the plaintiff of help from others.
This one is often the most dramatic. Picture a scene where a customer is struggling with a load. A bystander, maybe a former Eagle Scout, walks up with a heavy-duty ratchet strap and says, "Hey, I can strap that down for you."
A true Good Samaritan.
Exactly. But then the store employee steps in, physically pushes the Eagle Scout away, and says, "Back off. We don't allow non-employees to touch the merchandise." The Eagle Scout leaves. Then the employee fails to tie down the load properly.
Wow. So by chasing away the competent help, the employee doomed the customer.
Precisely. The customer would have received help from the Eagle Scout, but the rescuer's intervention prevented it. He left the victim worse off by isolating him.
Okay, those examples really clarify things. It's a high bar.
Yeah.
You really have to mess up, lie, or block others to be liable. You can't just be kind of bad at helping.
Correct. Imperfect help is not necessarily negligent help under this doctrine.
All right, now that we have the legal machinery in place, let's go back to Washington 2003. We are going to apply this strictly to the case of Henry Gano. We're going to use the proper analytical structure here to really see how the court thinks. Let's analyze Gano v. Lanogo Court. First, what are the legally dispositive facts?
So Henry Gano visited Lumberman's building center to buy a 12-foot beam weighing 100 pounds. He had a truck with a standard bed, about 6.5 feet long, with a toolbox in the back. A Lumberman's employee took Gano's receipt and used a forklift to lift the beam. He placed one end on the toolbox and the other end on the tailgate.
I'm visualizing this. A 12-foot beam on a 6-foot bed. That means huge overhang.
Massive overhang. The beam extended about 4 feet out the back of the truck. The employee asked Gano if he wanted it flagged. Gano said yes, so the employee stapled a red flag to the end of the beam.
And here's the million-dollar question. Did the employee tie it down?
He did not. He placed it, he flagged it, but he did not secure it.
Was there any conversation between them?
Very brief. After the employee placed the beam and flagged it, he said to Gano, "That's it."
That's it. Ambiguous. What about the environment? Was there any signage?
Yes, and this is crucial. In the lumber yard, there was a sign that read, "We will be glad to help you load your materials. However, before leaving our yard, please tie your loads securely."
So the sign explicitly told customers, this is your job.
Correct. And right near that sign, the store provided free twine for customers to use. Gano did not use the twine. He didn't check the load. He apparently thought gravity and friction would hold it. He drove off, turned a corner, the beam fell out, and when he tried to retrieve it, he was struck by a car, shattering his kneecap.
Those are the facts. Brutal. And what was the core legal issue?
The legal issue was whether Lumbermen's Building Center assumed a duty of care under the voluntary rescue doctrine by loading and flagging the beam, effectively making them liable for Gano's subsequent injuries.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the voluntary rescue doctrine found in the restatement second of torts, sections 323 and 324A. The rule states that a rescuer is liable for physical harm resulting from their failure to exercise reasonable care if and only if their conduct meets one of three elements.
Okay.
Element 1. Did the defendant's failure to exercise reasonable care increase the risk of such harm? Element 2. Did the harm equality result because of the other's reliance upon the undertaking? In other words, was the plaintiff misled? And element 3. Did the defendant deprive the plaintiff of help from others?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, increasing the danger? And I have to say, looking at a 12-foot beam balancing on a tailgate. It feels like the employee increased the danger just by putting it there.
That is the intuitive reaction, but the court disagreed. In the mini IRAC for this element, the issue was whether placing the beam into the truck constituted increasing the danger. The court's analysis relied on comparing the situation before the act to the situation after. Before the employee acted, Gano had a heavy beam he needed to load. After the employee acted, the beam was in the truck, but unsecured. The court found that the employee's act was neutral.
Neutral.
Yes, he didn't make the beam more unstable than it would have been if Gano loaded it himself. The danger came from the beam being unsecured, not from the method of loading. Therefore, the employee did not increase the danger. He simply failed to eliminate the existing danger of an unsecured load.
I see. So there is a difference between creating a risk and just failing to fix one. If I hand you a sharp knife, I haven't increased the danger of the knife, I've just handed it to you.
Exactly. Unless I hand it to you blade first while shoving you, that would be increasing danger. Here, the court concluded the first element was not met because the risk remained constant.
Understood. Now, what about the second element, misleading the plaintiff? This feels like Gano's strongest ground. The guy said, "That's it." To me, "that's it" means job done, you're safe.
Gano certainly argued that. For the mini IRAC on element 2, the issue was whether Gano reasonably relied on the employee's actions or words to assume the load was safe. The court analyzed the statement, "that's it," in the context of the environment. They held that "that's it" simply signaled the end of the loading process, as in, "I have finished my task," not a warranty of safety. Furthermore, the court pointed to the sign. The sign explicitly warned customers to tie their own loads.
So the sign overrides the vague comment.
Yes. And the court also noted that flagging a load is not the same as securing it. The court concluded that Gano's belief that the load was safe was a mistaken assumption based on his own lack of diligence, not on any deceptive act by the employee. Therefore, the second element was not met.
Man, that is tough. The court is really saying don't hear what you want to hear. Now, what about the third element, depriving the plaintiff of help from others?
This was the quickest part of the court's analysis. For this mini IRAC, the issue was whether Lumbermen's prevented Gano from securing the load or getting help. The facts showed that Lumbermen's actually provided twine for customers.
Right, the free twine.
The employee didn't stop Gano from using it, nor did he stop Gano from calling a friend or asking for more help.
So unlike our Eagle Scout hypothetical, nobody was pushed away.
Correct. The help was there. Gano just chose not to use it. Therefore, the court concluded that the third element was not met.
And after analyzing all the elements, what was the court's final conclusion?
The court affirmed the summary judgment in favor of Lumbermen's. Because Gano failed to satisfy any of the three elements required to trigger the voluntary rescue doctrine, Lumbermen's owed no duty to secure the load. The responsibility for the safety of the load on the public highway remained 100% with the driver, Henry Gano.
So Gano walks away with nothing. No settlement, just a broken knee and a legal bill.
That is the result.
It really drives home the point that just because someone helps you doesn't mean they own your problem.
That's the perfect way to phrase it.
I want to pivot now. We have a lot of listeners who might be law students or maybe business owners trying to avoid a lawsuit. We've gone through the case, but I want to turn this into a tool. Can you distill this entire module into a diagnostic checklist? If I'm facing a similar legal problem or an exam question, what is the framework?
Absolutely. This is the rescue reliability checklist. You should memorize this sequence. It acts as a funnel. Step 1, identify the act. You ask, did the defendant affirmatively undertake a rescue or aid when they knew danger was present?
Okay.
If the answer is no, if they just stood there and did nothing, stop P. There is no duty. You are done.
But if they did act, like the forklift driver?
Then you move to step 2, the worsening test. This is where the liability lives. You must ask 3 specific yes or no questions regarding the rescuer's conduct. Question 1, did they actively increase the danger compared to the status quo?
Right.
Question 2, did they say or do something specific to mislead the victim into reliance? And question 3, did they block access to other sources of help?
And how do I read the results of that test?
That is step 3, the conclusion. If the answer to all 3 questions in step 2 is no, the rescuer is not liable. It doesn't matter if they were sloppy, rude, or lazy. If they didn't make it worse via one of those 3 paths, there is no negligence under this doctrine.
That is incredibly useful. It strips away the emotion of the injury and forces you to look strictly at the change in the situation. Did I make it worse, or did I just fail to make it better.
Exactly. And that distinction is what keeps the voluntary rescue doctrine from freezing society.
What do you mean by freezing society?
Well, think about it. If we punished the lumberyard employee for helping Gano just because he didn't help perfectly, what would happen next week?
The lumberyard would tell their employees, don't touch the customers' trucks, don't help anyone, let them figure it out.
Exactly. We would have a chilling effect on human kindness. The law tries to balance two things. We want to encourage people to help each other, which is courtesy, but we don't want to punish them unless they actively create harm, which is custody.
That is a great final thought. The distinction between courtesy and custody. The employee offered courtesy. Gano assumed he had taken custody.
And that mistake is what caused the lawsuit.
Well, this has been an eye-opener. I'm definitely going to double-check my own loads from now on, no matter how nice the guy at the store is. To our listeners, remember, relying on a nod and a "that's it" is not a legal defense. Stay safe out there, and we'll see you on the next Deep Dive.